I think it's now officially the afternoon. So good afternoon, everyone, and thank you so much for joining us. My name is, as you can see on the slides and on the screen, is Dominique Smith, and I am a junior tenant at One Chancery Lane. I'm delighted to be joined by Ella Davis, who is also a junior tenant at One Chancery Lane. We both practice predominantly in clinical negligence work, personal injury, beauty treatment claims falling within that, inquests, travel and cosmetic work abroad. But as many of you know, this is the 1CL afternoon webinar. And today is actually really quite a special one. It's a momentous occasion because it's our 50th webinar. So thank you to those of you who have been with us for the ride. To celebrate that, you'll be pleased to know that we have a prize today. So we have a question, as you can see on the slides, which says, in a 2018 report, what percentage of patients reported that they did not know what products were used in their beauty treatments and how they were sourced? So the first person to guess the correct answer, or indeed get as close to it as possible if we can't, get the exact answer, will win a prize. So pop your comments in the chat box. We'll keep an eye on that and we'll announce a winner at the end. So it's now probably time to get started to the substantive meat of this webinar. What I will do is just start with some housekeeping first of all. As many of you know, with Zoom, there is a question and answer box, which should be at the top of your screen. Sometimes it's at the bottom. And if you pop any questions for us in that box, that would be fab. It's just because it's a bit harder with the chat to see what questions are coming in, particularly if we have answers to our prize question. And please do, if you can, avoid it just using the raise hand function. It's just because we don't know why you're raising your hand. It's quite hard for us to work that out. So just if you need us, again, put a comment in the chat box or indeed raise a question in the Q&A box. So this webinar, as you know, is one where Ella and I are focusing on beauty treatment claims. And this is quite an interesting area because beauty treatments are now so accessible to the public. And what no doubt has proliferated that and the use of these treatments, such as Botox and fillers, is the rise of social media and platforms such as Instagram and Snapchat, as well as the proliferation of reality TV stars on programs like Love Island, who may promote the treatments that they've had. We're also in an age of using Zoom and FaceTime and Skype and Microsoft Teams and the like. And so we're far more alive to what issues that we like or don't like with our appearances. Seeing ourselves on the screen gives you time to analyse and watch back how you look. And that, I think, also contributes in part. But people can now see that they can get essentially a quick fix and may want to emulate those they see in the media or achieve an appearance, such as one that they can edit on themselves with filters on Snapchat and Instagram. And they can do that for a relatively cheap price without recourse to surgery. The problem with non-surgical treatments are that many individuals are not alive as to what can go wrong and the risks of those procedures, but it's also a predominantly unregulated field, which could result in people who are not medically qualified administering these treatments. For most treatments, there is no mandatory education, qualifications or training and training requirements in administering those treatments. And what you do find is that the training courses in respect of those treatments, if someone undergoes them, can vary considerably in length, in content and in quality. Some allow practitioners to complete a course in only a day before they can go and offer treatments themselves. This is also a rapidly growing area because new treatments are constantly being developed, and that does present challenges for regulators. In terms of what can go wrong, you'll see on the slide a picture of an individual who had Botox, which unfortunately went really quite wrong. And you can see that she has some ptosis, so drooping in one of her eyes, and the other eye is forced quite wide open, and that's because the Botox was injected too close to her eyes. And these are the sorts of things that we are starting to see, particularly as this industry is proliferating. Often we can see that indeed a number of things can go wrong. So for example, in terms of skin reactions, in hairdressing claims, For example, when one doesn't carry out a patch test before using a particular hair dye. Something as simple as waxing can lead to burns or scarring, again, allergic reactions to the wax itself. And with laser hair treatment, laser hair removal treatments, those injuries can also arise. I have read also about cases where an individual's labia, for example, has been torn in a waxing incident, and they've then had to go and get recourse to a gynecologist to assist in their claim for obvious reasons. One of the cases that I've dealt with in this area involved injuries arising from contaminated aftercare product. So it may well be that the injury doesn't actually arise from the carrying out of the procedure itself, but it arises from indeed the advice that's given after and the products that are provided after the treatment in order to keep the wound clean. On occasion, you might see things such as something that's referred to as beauty parlour syndrome, and that's where someone goes to a beauty salon and tips their head back into a sink to have their hair washed, and that can unfortunately lead to strokes occurring. And I understand that the reason for that is because the neck is extended for a period of time, which can restrict flow to parts of the brain of the blood, and you may find that someone could alternatively develop a brain injury. A member of Chambers has had a case in this area where an individual suffered a stroke following a massage, and that resulted from the fact there was too much pressure put on the neck, leading to arterial dissections. Now, I've already spoken very briefly about Botox, and you've seen the picture on the previous slide, but there are other consequences that can arise from it, such as Bell's palsy, but indeed with fillers, I've read cases where they've led to facial abscesses and significant scarring as a result. No doubt many of you have seen cases in the media and newspapers and the like where individuals have had lip fillers which have gone wrong and the filler has been injected into a blood vessel. One thing I think we all need to pay a bit of attention to in terms of this area of litigation is in respect of potential linked risks between injectables and the COVID vaccine. Of course, we're still learning about COVID. There's still a lot we don't know, and the medical literature is in its infancy on this subject. But there have been reports, and indeed the GDC website refers to this, of complications developing when an individual has had a COVID vaccine either shortly before having filler injections or indeed shortly afterwards. And consequently, there might be some litigation, I think, that could result from that. There may need to be changes to consent processes, for example, asking whether someone has had their vaccine before administering any filler and making them aware of the fact there are some reported cases where complications have arisen. From a defendant's perspective, it could be argued that that wasn't foreseeable, but I only think that argument could probably hold water for a short period of time once more cases become known and we learn more about this. Now, as I've mentioned, the regulation of non-surgical treatments is a bit like the Wild West. It's an area that really does lack necessary regulation. What has now been implemented, however, is the Botulinum Toxin and Cosmetic Fillers Children Act 2021, and that makes it an offence to administer Botox or fillers for cosmetic purposes to a person under the age of 18. Now, previously there was no age restriction on having those treatments, and that legislation, I believe, came into force at the beginning of this month. But bear in mind that if Botox or fillers are administered for a clinical need, so not for cosmetic purposes, then that would not be an offence. There is a defence set out in section 414, namely that if a person can show that they were a registered medical practitioner or a regulated health professional, and by that it's a nurse, a dentist or a pharmacist, and that they were acting in accordance with the directions of a registered medical practitioner, or if they had taken reasonable steps to establish the person's age and reasonably believe that they were aged over 18, and that can amount to an offence. There are further offences that are set out in this Act, and they're in respect of business owners and corporate bodies. In terms of business owners, where a person is carrying out a business and a person other than an approved person administers Botox or fillers to someone under the age of 18, or where arrangements are made on behalf of a business owner for a person to administer Botox or fillers, that can amount to an offence. So booking an appointment for those treatments would seem to fall within that. The business owner can defend those allegations if they can prove that they took all reasonable precautions and exercised all due diligence to avoid committing the offence. Outside of this piece of legislation, the industry is largely unregulated, and whilst local authorities can adopt powers to allow the registration of practitioners and premises offering certain cosmetic treatments, they have few powers to refuse registration, which means that there are those that aren't suitably qualified or competent that could still register. So I'm now going to pass you on to Ella to talk about defendants and insurance.
Thanks, Dom. So yes, obviously, if you've got one of these cases, you have somebody who's been injured in the ways that Dom describes, the first thing you need to work out is who is the potential defendant to that claim. And of course, normally that seems like a very straightforward question in personal injury litigation. But in this particular field of beauty therapy, it can be quite complicated. In particular, a lot of beauty salons will run what are called rent-a-chair arrangements. So they will have individual therapists or practitioners who are not employed by that business, but rent a chair, are self-employed, and have sometimes quite complex arrangements, usually for the purposes of trying to avoid employment legislation, so that the salon doesn't have to employ those people, doesn't take on all the obligations of an employer, and it does give some freedom to and some tax advantages to the therapists involved. In terms of asking who the correct defendant is, the first thing you have to ask, of course, is what is your cause of action? And the very straightforward answer is that if you are bringing a cause of action in contract, the correct defendant will be the other party to that contract. If you're bringing a cause of action in tort, it will be either the tortfeasor or anybody who is vicariously liable for that tortfeasor or who could be said to owe a non-delegable duty. But that sort of very straightforward explanation belies how complicated these cases can be, because, for example, if you're trying to work out who the contract was with, well, a lot of the time there isn't going to be a written contract. There might be sometimes, but often a person will have turned up, handed over their money, received a beauty treatment, and there won't be any sort of written contract. So you need to look at things like who have they paid, who have they made initial contact with, who have they booked with. If they've booked through some sort of online system, does that contain terms and conditions that will, for example, set out that the salon is only acting as agent between the client and therapist? But you may need to do some more digging than you might expect to try to work out exactly who the client has contracted with. And then in tort, as I say, obviously the tortfeasor is somebody that you can sue. So if a therapist has slapped a product on you without providing a patch test, they're clearly negligent and the defendant that you might identify. But it may be that that therapist is somebody who is not likely to be able to satisfy a judgment, and you obviously would prefer to go after a salon or a business that is more likely to be able to satisfy that judgment. So that raises the question of vicarious liability and potentially non-delegable duties, though I think that's less likely. And one of the questions that we were asked to cover in advance of this webinar is whether beauty salons should be concerned about the decision of the High Court this year in the case of Hughes and Rattan, or whether it's confined to its facts. Now, as probably most of you know, that's a case that involves dentists. It involved a dental practice, and the question was whether the owner of that practice was either vicariously liable for 3 dentists who practiced at it, or could be said to owe the claimant a non-delegable duty of care and respect of the care that she received as a patient of that practice. And to answer the question, is it a decision that should cause beauty salons concern? The short answer is that, of course, all of these cases turn on their own facts. And therefore, the starting point remains, if you're looking at whether there's a non-delegable duty of care or vicarious liability, to go back to the principal Supreme Court decisions in this area. So if you're looking for a non-delegable duty, that would be, of course, the Woodland and Essex case. And you're looking then at the 5 factors identified by Lord Sumption in that case to establish whether there is a non-delegable duty, as there was held to be in the Hughes and Rattan case. I suspect in most beauty cases that those 5 factors won't be established, because the first of those is that the claimant is a patient or a child, or for some other reason is especially vulnerable or dependent on the protection of the defendant against the risk of injury. And other examples are given as prisoners or residents in care homes. And the second is that there is an antecedent relationship between the claimant and the defendant, independent of the negligent act or omission itself. So I think in cases where somebody simply walks into a beauty salon off the street and has a fairly straightforward treatment, they won't come within those first two factors. In Hughes and Rattan, which, as I say, was all about dentists, there was held to be a non-delegable duty, but of particular relevance in that case, the claimant was held to be a patient of the practice. She was a long-term patient. She had signed various registration type documents, of course. A dental patient is much more akin to a hospital patient. So I think that aspect of the Hughes and Rattan decision probably won't apply to most beauty claims. But the court also went on to determine in that case whether or not the practice owner could be vicariously liable for the actions of the dentists. And again, you have to be quite cautious reading across from Hughes and Rattan to beauty cases. Some of the important factors of Hughes and Rattan were, for example, the contracts that the practice had with the NHS to provide NHS care. Those sorts of matters won't arise in beauty cases. And again, the way you need to start is the Supreme Court's decision of last year in the various claimants in Barclays Bank case. And the question, of course, is whether or not there is a relationship akin to employment between the salon and the therapist. And what Lady Hale said in that case was that the question, therefore, is, as it has always been, whether the tortfeasor is carrying on business on his own account or whether he is in a relationship akin to employment with the defendant. So that is the test that has to be applied on a fact-by-fact basis to all of these cases. But there may be some interesting points emerging from Hughes and Rattan in that respect, in as much as relevant factors in that case were, for example, the provision of equipment, the opening hours of the provision of premises, the opening hours of those premises, the restriction on the contract with the dentist as to the amount of leave they could take, and then looking at it from the perspective of the claimant, the fact that she had booked through the practice itself. She didn't book directly with dentists. She paid the practice itself rather than paying anyone individually. And all of those sorts of features can, of course, arise in beauty cases as well. So it was probably a useful case to look at if you've got a beauty one, but I have to say I think all of these cases are unfortunately confined to their own facts. And as I say, really where you want to begin your analysis is with Woodland and with the various claimants in Barclays Bank cases. Can I have the next slide, please, Dom? So, having identified a defendant, the next question, if you were bringing this claim from a claimant perspective, is that defendant worth suing? And specifically, of course, you're going to want to know, are they insured? Because again, what differentiates the sorts of claims we're talking about today from more classic cosmetic negligence type cases is that there isn't requirement to have the sort of compulsory professional indemnity insurance that dentists, medics, and other professionals have. And even if you can establish that a beauty salon or therapist has, as they should, some sort of public liability insurance, there may still be indemnity issues with that insurance. For example, they may not be providing treatment that is covered by that insurance. There can be issues that arise of late notification of insurers that there's a potential claim. So what the claimant will want to know before bringing the claim, of course, is there insurance to meet it? And the flip side to that is that if you're acting for a defendant, you probably aren't going to want to reveal that information, particularly if the answer is that there is insurance to meet the claim. The position really is that the defendant can't usually be made to disclose those insurance details in the vast majority of these types of cases. There are statutory provisions that relate to the provision of information about compulsory insurance for professionals, but again, that doesn't really arise in our circumstances. And there are two other ways that a claimant might be able to force information about the insurance position of a defendant. But again, both I think are going to be a struggle to apply to beauty cases. So the first, as I've set out on the slide there, the case of XYZ and various companies. That was a case arising out of breast implant litigation. Litigation that's obviously given rise to lots and lots of reported decisions, huge group litigation involving multiple claimants and defendants, and obviously extremely high value litigation. And that decision set out on your slide is a decision of Mrs. Justice Thirlwall, as she then was, when she was asked to make an order requiring one of the defendants to set out their insurance position. That application was made partly under Part 18, which obviously can be used to obtain information from a party about a matter which is in dispute between the parties. But Mrs. Justice Thirlwall held that actually the existence of insurance wasn't a matter in dispute between the parties. It was a matter of interest to the parties, but it wasn't actually a matter that went to the disputes in the case. So Part 18 was of no assistance to the claimants. Similarly, there have been cases holding that Part 31 and the requirements of disclosure are of no assistance because, again, insurance is not generally a matter which tends to support or undermine a party's case. But what she did look at in that case was Rule 3.12M of the CPR, which, although I know you know it all, anyway, I'll remind you, provides that except where the rules provide otherwise, the court may take any step or make any order for the purpose of managing the case and furthering the overriding objective. And Mrs. Justice Thirlwall was satisfied that that rule gave her the power to order one of the defendants to provide to the court a witness statement or statement setting out whether they had insurance adequate to fund their participation in the litigation to the completion of the trial and the conclusion of any appeal. That knowledge would permit her to case manage the litigation on the basis of adequate information. So it's an extremely limited exception to the usual rule about defendants not being forced to disclose insurance details. It didn't extend to whether or not they had insurance cover for damages. It was only in relation to their ability to fund their participation in the litigation. And as I say, it has to be viewed in the context of that extremely high value, complicated group litigation. So I don't think it's going to assist most of the types of claims we're talking about, even the higher value ones. And then the second way that a party might forcibly obtain information about insurance cover is a third party's Rights Against Insurers Act 2010. But this again is quite a limited means of obtaining any information. The right under it to obtain any insurance information only arises where a person reasonably believes that another has incurred liability to them and also reasonably believes that that person is a relevant person. That means that they have become insolvent. So you have to have a reasonable belief that the potential defendant is insolvent before being able to use the power under this act. There's no assistance to a party who wishes to bring proceedings but is unsure about the insurance status of the potential defendant. Where it does arise, though, the information that can be requested is quite far-ranging. So that includes whether there is a contract of insurance, if there is such a contract, who the insurer is, the terms of the contract, and importantly, whether the insured has been informed that the insurer has claimed not to be liable under the contract in respect of the supposed liability. So in short terms, whether there's any indemnity issue. And having made that request, the defendant has to respond, and if they seek to withhold any of that information, then an application can be made to the court. But of course, they may do so on the basis that they say, we're not insolvent, and therefore you're not entitled to it. So again, it's a very limited way of obtaining any information. The only other practical point that claimants might want to think about if they're unsure about whether a defendant is insured is in circumstances where they have had any correspondence in response, any sort of letter of response. If that's come from solicitors, the identity of those solicitors might give an indication as to whether there's likely to be an insurer in the background if it's a panel firm, or if it's come directly from, for example, a defendant, therapist or salon. Sometimes the tone of that correspondence or the terms of it can give a clue as to whether there is any sort of professional advice in the background, although it won't tell you whether that professional advice is being funded by insurance. But one of the questions we were asked in advance of this webinar is, well, if you sent a letter of claim and not had any response, do you press ahead? I'm afraid that really is a question for each case and the level of risk that a claimant is willing to accept. It is worth pointing out that if you are suing an individual, for example, in these cases, and the claim is one of relatively modest value, then you may simply want to try to establish whether or not there are assets to meet the claim. And it may be that then you can proceed even without there being any insurance, but that's a matter for the lawyers and clients involved and their appetite for risk in this area, I'm afraid. Next slide, please, Dom. So then you have to consider your causes of action, because I think a lot of us as personal injury lawyers, we tend to normally be bringing claims in negligence, and we don't think about the availability sometimes of other causes of action. But in this area in particular, there may be others. So as I say, if there's been a service for which the claimant is paid, there is a contract between the parties, and simple breach of that contract will give a cause of action. Misrepresentation, as well, if the service turns out not to be as represented. And it's important to bear in mind that in these more contractual claims, obviously you're not limited to proving injury in the same way that you might be in a tort claim. That claim in contract can include a claim that the service was not either provided to the expected standard or was not as described. So, for example, we've been asked about tattooing cases. And if, for example, you've carefully spelled out your middle child's name before getting the tattoo and then been given something else when the tattoo's actually been completed, it seems to me there's a potential contractual claim there, even in the absence of any specific injury. And there's also the possibility of product liability claims where a beauty salon or therapist has provided some sort of product, particularly aftercare solutions. And Dom, I think you were going to say something just briefly about that.
Yes, it's just in relation to a case that I had on this issue. And so the product that was provided to the claimant in that case was indeed contaminated, and we were able to use the Consumer Protection Act in proceedings, because I'm just reminding myself of the Act that it's section 2, I think, which is where it says that a producer of a product is liable where damage is caused wholly or partly by a defect in the product. And the meaning of defect is essentially that the safety of the product is not what you would expect. So that's another possible route if you've got a dodgy aftercare solution or something's been contaminated along the way, that you could use that as a way of getting a producer of that product in the proceedings.
Thanks, Tom. Have the next slide, please. And just briefly, I've reminded you all of the Consumer Rights Act 2015. I'm not going to say a lot about it, but of course it does imply terms into all consumer contracts, including the term of satisfactory quality, that services be provided with reasonable care and skill. And section 50 is one that is worth bearing in mind, that any information that's given about the service will be treated as binding if it's taken into account by the consumer. Next slide, please, Tom. Another cause of action that is worth bearing in mind, and particularly in the context of what I've said already about sometimes the difficulty with establishing insurance or identities of defenders, is section 75 of the Consumer Credit Act 1974. And that has the effect that if a service is paid for by credit card and the claimant has any claim against the supplier of that service in respect of a misrepresentation or breach of contract, the claimant will have a like claim against the credit card company. So if you're concerned about your claim against the actual supplier of services, this is another potential route of claim. Indeed, it is one that was used by some of the claimants in that XYZ case. The claimant must have paid with their credit card. It's unlikely to be satisfied if somebody else has paid for the service for them with their own credit card. And the value of the services, and that's important, it's the value of the services as distinct from the amount paid on the credit card, must be between £100 and £30,000. So it seems to me that will cover a lot of the claims that we are talking about here. There's no strict requirement to also sue the supplier, although I would suggest that in many cases it may be advisable to do so, simply because, of course, there are issues about trying to later bring in other defendants if that claim doesn't work. That's something you'll have to decide on a case-by-case basis. But it's another route potentially to recovery in a breach of contract claim where there are any issues about suing the supplier themselves. The next slide, please, Dom. One of the particular issues in these cases for claimants and defendants is establishing the standard of care. Again, as Dom set out at the beginning of this webinar, that this is an industry that is really very largely unregulated. So whereas in a clinical cosmetic claim, you would simply go and obtain a report from the appropriate clinician, and that clinician obviously will have experience, they will have gone through the same training, they will be regulated by the same regulators, there are insurance requirements. It's very straightforward for a medical expert to give an opinion as to what is the appropriate standard of care. These claims are a little bit more difficult, but still perfectly possible to establish the standard of care. It just takes a little bit more imagination and a little more creativity sometimes. So one of the first issues is the issue of foreseeability, because some of the injuries that we see are perhaps quite surprising. Some of the treatments that we're talking about are new treatments, but the question will be whether or not the particular beauty therapist ought to have foreseen injury arising in this manner. So, for example, Dominique mentioned at the beginning the issue of beauty parlour syndrome and the issue of strokes. Now, I suspect many members of the public might not be aware that that is a risk these days, but actually it is now a very well-known risk in the industry, and one that I would suggest most people ought to be aware of. Similarly, there's the issue about the interaction between injectables and the COVID vaccine. And it seems likely that as more cases of that are reported, it would be reasonable to say that a beautician ought to be foreseeing those issues. A quick word on experts, because as I say, we're used to using experts to prove more classic clinical negligence claims, but they're not necessarily going to assist you in the same way in beauty treatment claims. It seems to me, in theory, there is absolutely no reason why you should not be able to rely upon somebody holding themselves out as an expert beautician. As long as they can establish they have the relevant expertise, it should be possible to get in somebody who has performed the relevant beauty treatment before and give opinion evidence as to the way that it should be done. The difficulty is that I just don't think there is a body of those experts at the moment. We know that most of the medical experts that we instruct, a lot of them have been on training courses. They can show that they know what their Part 35 duties are. They've written reports before. They come recommended by our colleagues. I just don't think the same is necessarily true of beauty experts yet. But I'd be interested if anyone thinks that there is a body of them. Please let us know in the chat. But what you may be able to do in certain cases is use a more medical expert. And I think the argument for doing that becomes much stronger where we're talking about the much more invasive beauty procedures. So not your hairdressing or your waxing or nail procedures, but where we're talking about the use of lasers, the use of injectables. It seems to me that if that person is holding themselves out as having the sort of skill to be able to use that equipment and to perform those procedures, they are holding themselves out as having skills and qualifications not that far off clinicians And somebody like a dermatologist may be, in fact, an appropriate expert to give an opinion on how, for example, a laser should be configured and used, how injectables should be administered. And I think that argument becomes stronger the more invasive the procedure that you're talking about. There are other sources, though, slightly more straightforward than expert evidence or factual evidence that you can use, whether you're acting for a defendant or a claimant, to establish the standard of care. And one of those in particular is that while this is an industry that hasn't been regulated by the law as yet, there are a number of voluntary bodies who have recognised the problems that we've identified at the beginning of this webinar, who have set up codes of practice and standards that they think responsible beauticians should be complying with. And of course, consumers can then look for beauticians that have been accredited by those bodies or do comply with those standards. And if you're defending a case and are acting for a beautician who can show that they've complied with those standards, they may be very useful in terms of mounting a defence. Can I have the next slide, please, Dom? Again, others really obvious sources, but look at things like operating manuals. So if you're using equipment, how does the manufacturer say that equipment should be used? Product instructions. So the way that often these cases can be evidenced is, take, for example, a skin reaction type case. You will have a medical expert who will say that either the skin reaction was or wasn't caused by the application of a particular product. And then you can take the product instructions, a label on the bottle that will almost certainly say, may cause skin reactions, use a patch test first. That will be useful evidence of the standard of care to be applied. It's also right that many beauticians now have certain qualifications, so they might have, for example, NVQs or other training courses, and it's worth looking at what they've been trained. That will also help with that question that we raised about foreseeability. If they've been trained that particular injuries can occur from particular treatments, then it's very difficult to argue that that's not foreseeable. But it is important to look, if you're doing that, at the particular content of the course that that person attended, because I understand they can vary quite a lot, both between course providers and over time. So again, if you're acting for a defendant, you probably want to try to find out exactly what your beautician was trained in, what information was available at that time, what was foreseeable to people who were being trained and they were trained. And I think with that, I'm going to hand over to Dom to talk through some quantum issues.
Yes, thanks, Ella. So in terms of quantum, of course, it depends really on your cause of action, what you're going to be seeking. If you're claiming for personal injuries, again, it depends on what injuries have been sustained as to where they're going to fall within the JC guidelines. But we do often see in these sorts of claims that psychological injuries and indeed some quite profound psychological injuries are claimed for, because understandably someone may have, for example, significant scarring on their face following an abscess that was caused by filler treatment. That obviously will then lead to issues such as that. Again, in terms of the refund of the cost of the procedure, depends whether this is a contractual claim or not. And what often we will include within schedules of losses and the like for these sorts of claims are the costs of rectifying any issues, indeed of, again, if there's psychological issues, the CBT and the like that may be required, or indeed the corrective procedures that may need to be undertaken to put someone in a more favourable position in terms of their injuries. Notably, we see a lot of really hefty skin camouflage claims, and I would just really caution you in terms of some aspects of that, because what we tend to see is that if someone has, say, a small scar or burn or the like, that there are often really hefty claims that are brought in terms of the camouflage makeup and the like that they require. And I think that particularly when you're looking at this either from a claimant or defendant perspective, that you have to think about if that's really required, because some may argue that indeed you might be able to find a high street product, like concealer, for example, that might do just a sufficient job, And really, you have to ask yourself as well, how likely is it that the person's going to use it? If it's an injury to somewhere that's not on the face, you may find that they don't really need that makeup every day, and those sorts of questions may be asked either in Part 35 questions or by a judge. And indeed, you might want to explore that with any expert that you have to make sure that any claim, if you are for a claimant, for example, in that respect is sound. Otherwise, if you're for a defendant, you may wish to ask a number of questions, or indeed instruct your own expert if the case is of such value, to see whether this is a product that's actually required. So that's what we tend to see in those sorts of claims, but a lot depends, as I mentioned, on your cause of action really, and what's going to be the necessary result. We often see things, for example, like scar revision and the like, if someone's been scarred and if that's amenable to surgery. And those are the sorts of considerations that you'll want to be thinking about when bringing these claims, or indeed when you are defending them. But I think that leads us, we stayed within the 45 minutes quite well. That leads us to the end really of this webinar, apart from questions. And what I should say before we get to the questions is we did have a winner in terms of our 50th webinar prize, and that winner is Lydia Windrow. The correct answer was 84%. So in terms of some questions, we've had some questions before you all go on the screen. So one of them is from Graham Boundforth, and he says, what about those model days where treatment is free, but volunteers agree to before and after photos? And Anna, I don't know what your thoughts are, but I think that just because it's free doesn't mean it's a caveat for negligent treatment.
No, I mean, obviously, if there's truly no consideration, there's no contract, so you won't have a breach of contract claim. And I suppose if what you're just saying is that the treatment ends up not being as described and the person ends up with, for example, not the haircut they were expecting, it's hard to see that there's any cause of action there, because obviously in negligence, you are going to need to show some loss. And I don't think that is simply not having the haircut that you wanted is a loss that's likely to give rise to a cause of action. So I think there you are probably a bit stuck.
And we've had another question from an anonymous attendee about, it says that with the potential criminal legal issues regarding more extreme body modification, scarification and the like, would a civil claim be able to succeed? And I guess that depends on what the criminal case covers, because if you're given compensation with the Criminal Injuries Compensation Board for your injuries, I don't know whether I think it'd be double recovery if you got the same.
Yeah, I mean, you couldn't do that. It seems to me though that actually that does raise another cause of action that we've not covered and probably should have done, because as I understand it, in those criminal cases, what's being said is that people can't consent to that sort of body modification, that it ultimately amounts to a battery. And it seems to me that if something is a criminal battery, there's no reason why it shouldn't be in tort as well, and why you shouldn't therefore have a civil claim. So that's a really good point. I suppose the most extreme example that could even answer the point about model days, in as much as if you've actually done something that somebody has not consented to, then in a very extreme case, you could argue that that's a battery, but probably not just because the haircut is not exactly as somebody wanted.
So we've had another, which is, have you dealt with any claims where the training body has been implicated in a claim, having poorly trained the individual who chose an inappropriate treatment and applied it poorly? I can't say that I have. That's quite an interesting question, but Ella, I don't know if you have on that particular point.
No, I haven't. I think the issue you'd probably run into in a claim of that nature is establishing a duty of care owed by the training body to the end client. I think it's probably quite unlikely that you could say that there is a duty of care owed by a training body to all the people that might be treated by that trainee. I'm not sure there's the necessary proximity to that.
So we've got a couple more questions.
Coming in thick and fast now.
I know. So one is from Kevin Hegarty, who says, treatment such as Botox is provided often by qualified dentists and GPs, although I have seen it often being provided at Botox parties and things like that. But he says, if such treatment results in an adverse outcome, what are your thoughts on what type of expert should be engaged to report on the breach of duty? And he suggests a plastic surgeon, if it's a dentist or GP administering it.
I think it's a dentist or GP that you want for breach of duty. If they are doing it, then you need an equivalent professional, it seems to me, for breach of duty.
Absolutely. We've had another one saying, would mole extractions be regarded as a cosmetic procedure? Well, it depends if they're removed, I guess, on the basis that it's a cancer 14-day turnaround. So if it's removed for those reasons, then it wouldn't be. I wouldn't have thought a cosmetic procedure. If it's for the purpose that someone doesn't like it and wants it removed, then I can't see why it isn't.
No, but again, I would have thought those are normally being done in the clinical context. So those are probably a bit more straightforward.
I would think so. I mean, mole removals usually, from when I've come across them, are carried out by GPs. So it may be in a private setting, but that's where you usually see it. But as you say, I think that makes things easier in terms of breach and evidence.
I certainly hope no one's cutting those out on the high street, but I may be wrong.
A bit worrying otherwise, but okay. So we've had. So someone says, what are your thoughts on patch testing and record keeping? What if the defendant says that they did do it, but they don't have records? In terms of that, I don't know what your views are, Ella, but in terms of record keeping, I tend to find that it's a bit like we see with most clinic cases and PI cases, that if records aren't properly kept, it's difficult for a defendant to say that they did do it if they've got no record of administering it, unless, of course, the claimant says, well, I did have one, but I'm assuming that's the issue in dispute.
Yeah, and I suppose similarly to clinical cases, people can speak to their normal practice. So a defendant might say, well, I've got no note of having done it. And they may not ever keep those notes, but they would say that's something I just always would do. There's no patient that no client that I've ever not done that on. No. And that would just be a credibility issue for their witness evidence.
No, absolutely. So we've had a couple more, some of which, just having a look now, just going through. Mark Phillips says, a client's receiving a treatment which requires the application of heat using a drying cap and dryer. The client is given control over the temperature but suffers a burn to their neck. Has the salon discharged their duty of care? That's an interesting question, Mark. I mean, I'm guessing there's a possibility of some contrib there. But I don't know if is it sufficient to discharge the duty of care?
I don't think it probably is. I don't think, because the salon, again, they may not be a sort of qualified professional in the same way, but they are holding themselves out as knowing what they're doing with this treatment. The client isn't. It seems to me if the salon has applied that drying cap and dryer, it's for them to make sure that it's done properly and to give appropriate information to the client so that they can control it themselves. But I don't think you can just pass the buck on to the client and say, you've got control of it now.
No, absolutely. I think that's going to be really, I don't think a court would like that, if I'm honest, if you turned around and said to a judge, well, they had control of the remote or whatever it was, and it's really all completely their fault. I don't think that's going to wash particularly well.
No.
So we've had a couple. I should say, I think we should only take one more. I'm conscious of the time that everyone will need to get back to work, so perhaps we do one more. So I've had one which is from Inderjeet, which says, have you dealt with any claims made against bridal makeup artists? These artists tend to use wide-ranging products, and is there an onus on the artist to have a disclaimer signed by the bride to protect themselves in case there is any reaction on the wedding day? Which I haven't had any claims in that area. I don't know if you've had any makeup claims there, Ella, but that's not something that I've come across yet.
Not that specific question. I mean, again, I think generally with disclaimers, you do have to be a little bit careful if you're acting for defendants and relying upon them. They are not likely to be all that effective a lot of the time. Again, it seems to me the issue with that is that you should really be doing appropriate patch testing if you can. If you can't, then I think, yes, if you warned a bride, we didn't do a trial, we've not patch tested these products on you before, I can't guarantee you won't have a reaction, then probably you've done all that you can.
Yeah, I agree. I think that's really all we have time for. What I should say is that our email address is on the next slide that I'll put up. But next time, David Thompson and Francesca O'Neill are going to be talking about limitation and date of knowledge. So do join them for that. But if you have any questions that we haven't had a chance to deal with today, or indeed that you want to pick our brains on, our email addresses are on the slide. If you don't get them down, just contact Emma, who's our marketing manager, and she will pass them to you. But thank you so much. It's been a real pleasure speaking to you all, and I hope you have a lovely rest of the day.
Thank you all. Have a good afternoon.
Take care, everyone. Bye.